The Madhya Pradesh High Court, in its order dated March 14, 2024, quashed a case of 498A against a mother-in-law who was accused of meddling in the household chores with her daughter-in-law. The High Court said that such day-to-day objections raised by mother-in-law cannot be deemed as cruelty to her daughter-in-law. So what was this case all about? Respondent number 2, which is daughter-in-law in this case, got married to respondent number 1, that is mother-in-law's son, in April 2016 at Jabalpur in Madhya Pradesh. Now, this was a love marriage attended by both sides' family members, and at the time of marriage, the mother-in-law was working in Uttarakhand. However, after 4 months of the marriage, she took voluntary retirement and shifted to Pune to reside with her son and daughter-in-law. Come 2021, the daughter-in-law now files a case, that is an FIR, against her husband and mother-in-law at the Maila Thana in Jabalpur under sections 498A, 506 read with section 34 of the IPC and section 34 of Dowry Prohibition Act. Now, let us understand what were the allegations made by the daughter-in-law. According to her, her mother-in-law started interfering in day-to-day life and was abusive, which kind of affected her mentally. She claimed that the husband too sided with his mother. The daughter-in-law then alleged that the mother-in-law was unhappy with the marriage and her husband would regularly demand dowry in the form of car and flat. She also informed court that she would spend from her own savings to purchase expensive household items as demanded by her husband. Now, though this was a love marriage, the daughter-in-law also accused her husband of being impotent as she could not conceive for 7 months post-marriage. Further, she claimed that after the mother-in-law went to US to reside with her daughter and son-in-law, the husband too perhaps could leave the country for good, spoiling her life. Thus, she asked the court to even seize his passport. Not just this, but the wife also accused her husband of speaking with other women frequently over the phone and pressurizing her to leave him. Adding further, she said that the mother-in-law was also not intervening between the couple to clear their differences. Neither she attempted a reconciliation between the husband and wife. Subsequently, without any recourse, she had no choice but to file an FIR against her husband and the mother-in-law. Now, let us understand what was the defense from the other side and what did the mother-in-law have to say. The mother-in-law has challenged this FIR and submitted that even if these allegations are accepted at the face value, no offence would be made out warranting prosecution of the applicant. How did the Madhya Pradesh High Court view this case? The bench of Justice Gurpal Singh Ahluwalia analysed the allegations on record and made observations step by step. With regards to the interference into day-to-day household chores, Justice Ahluwalia said that if the mother-in-law had been objecting to household works of a daughter-in-law, by no stretch of imagination, it can be said that this would fall within the category of cruelty which has been defined under Section 498A of the IPC. The High Court further added that if the daughter-in-law gets mental harassment on account of certain objections raised by the mother-in-law in the household work, then it can be said that the daughter-in-law may be hypersensitive. But certain disputes with regard to household works would certainly not amount to cruelty as defined in the law. The bench also noted that the mother-in-law chose not to intervene between the son and the daughter-in-law, and that was a personal choice not to get involved in the personal matters of her son and his family. The High Court then observed that the mother-in-law now had already relocated to the US, where she was residing with her daughter and son-in-law, and this signified a physical separation from the matrimonial dispute between her son and the daughter-in-law. Justice Ahluwalia also said that a bald allegation that the daughter-in-law was deprived of love and affection of her mother-in-law would also not amount to cruelty. Although said fact, if considered along with other circumstances, may become important, but in the facts and circumstances of this case, the aforesaid allegation would not amount to cruelty. Lastly, the High Court expressed that even if all the allegations in the FIR were accepted at the face value, no offences under Section 498A, read with 506(34) of IPC, and Section 3(4) of the Dowry Prohibition Act would be established. Accordingly, this FIR against the mother-in-law was squashed. Now, what is our take in this? Do these cases really need to be taken to court? Should such day-to-day domestic matters be taken to court or police? And if yes, then why is only the daughter-in-law empowered to do so? Why not empower the husband or his family to equally file cases of cruelty and domestic violence against the daughter-in-law? What is your opinion in these cases? Do let us know in the comments below. You can hit that bell icon and subscribe to Voice for Men India so that you can be updated with all the new videos as in how we broadcast them. Do follow us on our social media handles, which is X, Instagram, Telegram, Facebook @Voice for Men In. And you can also read our articles and case orders on voiceformenindia.com. Thank you very much for watching. Namaste. Jai Hind.